It is 2 o'clock.
Well,
We'll
it's
call
supposedly
the
you're not-
RPC hearing to, should we say committee is called to order? It's actually a hearing. Shouldn't we just say,
can
after
say
all this
hearing
time
today.
reading it, now it's finally hitting on me that we should say call the
You
hearing
can call
to
it
order.
hearing.
Okay, with that being said, good afternoon, ladies and gentlemen. This is a hearing conducted by the Resource Planning Committee of the Door County Board of Supervisors. My name is Ken Fisher. I'm the chairman of this committee and represent District 10, which is in the city of Sturgeon Bay. I'll have the other committee members introduce themselves.
Good afternoon, I'm Dave Leinau. I represent District 20, which is the village of Sister Bay and a portion of Liberty Grove.
Good afternoon, my name is Susan Kohout. I represent District 6, which is town of Sturgeon Bay in the southeast corner of the town of Nassawapi.
Good afternoon, my name is Dave Enigl. I represent District 17, which is the village of Egg Harbor, portions of the town of Egg Harbor, portions of Jacksonport, and portions of Bailey's Harbor.
Good afternoon, my name is Don Sitte. I'm County Supervisor District 19, which represents part of Bailey's Harbor and part of Liberty Grove.
And this is Mariah Good, the planning director, and Sue VanLangenberg, the zoning administrator too, and they will serve as clerks this afternoon. The purpose of this hearing is to gather testimony on the various cases on today's agenda. You are encouraged to explain how your interests are affected, how the public is affected, and to bring out any facts pertinent to the case related to public health, safety, convenience, and general welfare. There are two types of cases on today's agenda, zoning amendments and conditional use. In the case of a zoning amendment petition to amend either the map or the text of the county zoning ordinance, our committee conducts this hearing and makes a recommendation to the entire county board of supervisors to either approve the petition, approve a modified version of the petition, or to deny the petition. The county board will make the final decision on the zoning amendment petitions. In the case of a conditional use permit application, the Resource Planning Committee will hold this hearing and we will make the decision at a regular open meeting in the near future, likely later this afternoon if time allows. These decisions are normally final, but may be appealed to the Door County Board of Adjustment. The procedure we will use this afternoon in conducting these hearings is as follows. I will read the legal notice and will then call on the clerk for an explanation of the case. Resource Planning Committee members will then report any background information they have. There will be 2 rounds of testimony from those of you in attendance. The applicant will go first, followed by others in favor. Those in opposition will speak second. Persons with only questions or concerns should speak as if they are in opposition. The second round is for purpose of rebuttal. Only those who spoke in the first round may speak in rebuttal. Because of the need to prepare a clear record of your testimony, I ask that only one person come to the table at a time. If you want to testify, please come forward, state your name and address, and then present your testimony. Statements from the back of the room and exchanges between parties will not be allowed. Speakers presenting repetitive or irrelevant testimony will be excused from the table. Following this afternoon's hearings, the committee will adjourn and reconvene to its regular business meeting. You may observe those proceedings but may not participate in them. Please take this opportunity to silence cell phones, pagers, and similar devices. And I forgot again, so bear with me while I do that. There we go. Okay. We'll start with the town of Sevastopol. Rick Gerhardt petitions for an amendment to the detailed zoning map of the town of Sevastopol to rezone a 2.23 acre parcel from countryside CS to single family residential 20,000. The rezoning request is being sought so that they can sell a small portion of land to the adjacent lot to resolve a side yard setback issue on that adjacent property. The parcel is located at 4371 State Highway 57 in Section 26, Town 28 North, Range 26 East.
Okay, so if we look, and maybe we can blow, there we go, blow up the survey. This is the, survey of the property in question. It's about 2.23 acres in size. In the countryside zoning district, there's a 10-acre minimum, so this is a grandfathered lot. And what I wanted to point out here, this is the neighbor's attached garage attached to the home, which is roughly 5 feet from that lot line. What they're hoping to do here is rezone this parcel to single-family residential 20,000, which requires a 20,000 square foot lot, just under a half acre, so that they can sell a portion of the southern piece of their land to the neighbor. So the neighbor can add that to their parcel and then meet the required setback here. And now I'm gonna jump ahead to page 30. The reason behind this, and you'll see that you had a letter in the packet from the neighbors, the Frondas. They had done some remodeling and had some issues with that, and you'll see on the air photo, and again, these are not survey lines. The lot lines are dropped on the air photo, which aren't always accurate, but the attached garage had to be reconstructed on the existing footprint because of issues. They did not realize that they needed a permit from the planning department, and in working with them on a subsequent project, they had found out that the building was rebuilt without a zoning permit. So in order to correct that and be able to issue the permit for this, the neighbors are trying to help them out in this situation so they can sell some land so that they can meet the required setback and resolve the issues that they have uncovered. Obviously, if you read the letter from the Frondas, they ran into a lot of issues when remodeling, and so they're hoping to resolve that problem today with the rezoning. If we now move to the zoning map on 27, you can see the parcel in question right here is highlighted. There's a rather large area of countryside with this small area of single-family residence adjacent to the parcel in question. It's made up of several single-family residents to the north here. And then further to the west and north are larger lots, countryside, then surrounded by prime ag. And really that the crux of the case is that they're really just trying to rezone the property, the neighbor's property, so they can sell some and reduce the size of that parcel to help them out. And at this point, I'll turn it over to Mariah for the planning considerations.
Sorry, I gotta find this standard part.
Page 13.
13?
Planning is 15.
The parcel in question is actually designated as residential on the future land use map, so obviously the requested district is just as good a fit, if not a better fit, than the existing. I wasn't too concerned as far as whether or not it would constitute a spot zoning, because I really don't think it's gonna lead to any further development of either parcel, and like Sue said, it's just being done to try and resolve a setback issue. One thing Sue didn't explain is why they're not pursuing a variance, and the reason that they're not pursuing a variance with regard to the setback issue is that they wouldn't qualify, because it was a self-imposed hardship, and in theory, they could have built a garage somewhere else on the property, so this seemed like the best route to go as far as resolving the problem.
Quick question. I'm sorry, go ahead.
No, that's right.
Is the parcel we're talking about to rezone directly adjoining the SF-20? Or is there?
Do you want me to go back to this?
Correct. Go back to the zoning map on 27.
Whoops.
Two more. I'll show you. So the corner, and we don't,
Let's
to
go back to
next
the other
page,
lot picture.
down
I say the next one
128.
is better.
Yeah.
There we go.
You'll see
Okay.
that SF-20, the big chunk of SF-20 is here. This is owned by Schaefer, and this is the lot in question. So it does abut the SF-20.
Thank you.
Everything's at angles there.
Question? Was there talk of a deck?
Correct. The reason that we came upon this was the owners to the south were proposing a deck, which we can talk to the applicants. I believe the deck will work. But while speaking to the builder and the owner on site, it was.
So it's not that the deck would be the setback problem, it's that the garage, which is there right now.
Right, that
Okay,
got
I understand.
reconstructed, yeah.
So why, if they're reconstructing on top of the same footprint, is that not permitted?
Because it's considered new construction, and any new construction needs to comply with the ordinance requirements.
So but they kept the same foundation slab that the garage was on, or they
Doesn't
took
matter.
that, it doesn't matter.
Any other questions?
Yeah, it doesn't matter because it's, it's a brand new construction from bottom to top? Or is it because it's, part of a new construction? In other words, if you tear down the building, you need a permit, but if you tear down half the building, do you need one?
Yes, and the new part that you're building would need to comply.
That begs the question then, do you have to get a permit if you tear down any portion of the building?
Yeah, I mean, like if you tear a wall down and you're gonna build a new wall, then you do need a permit.
Okay, thanks.
So
Okay.
that line is gonna get fuzzier as we move further into the shoreland.
I thought of that and I didn't
But
even
we're
wanna
not
ask.
anywhere near the water, so
Yeah.
it's, yeah.
Thanks, Mariah.
All right. Would the applicant please come forward?
If you need to point, it's the yellow button.
Sure. My name is Rick Gerhardt. I reside at 4371 State Highway 57 in Sturgeon Bay. Yes, it's pretty much cut and dried why we want to move the line. We're just helping out the neighbors. There is a tree line right behind the line that we're going to move, so it wouldn't affect our privacy in any way. It won't even come into the tree line. We just like to help them clear up the issue that they have with the setback.
Yeah, can you,
Does that show you
That's
better?
the true.
Yeah. This line right here would be moved in a ways. This is a huge tree line that sits right here. So even if we move that line back, it wouldn't really affect us at all. A few years ago, we actually tried to sell them that, but with the zoning in Sevastopol, we didn't have enough property to allow them to have that little parcel, so that's why we're here today.
Okay.
Just to clarify, it certainly looks like they've been using parts of your land already, right, based on this aerial? Looks like there's a car parked there, another shed or something like that.
That's just a little open area and whatnot. Yes, I gave them permission to use it.
Okay.
Yeah, yeah. I have, when we purchased the house, we didn't realize that the lot line came out so far. We figured it was the tree line pretty much. When we found the stake, it was like, oh, right in our backyard. So that wouldn't affect us in any way at all.
Good. Any other questions? No? Okay, thank you.
Thank you.
Anybody else wishing to speak in favor of the proposal? Anybody else wishing to speak in favor of the proposal? Okay. Are there any, sure, come on up. Sit down, state your name and address.
Torrey Fronda, 4355 State Highway 57. Yeah, we didn't realize when we were doing the garage, we didn't plan on doing anything with the garage at the time. We had some old problems, so we ripped down the back of the house and redid the house part of it. When we got to the garage, we realized that it was all made out of a log and everything was made out of a log. It was starting to come in. So how it all started is we called our, I just wanted to see if we could do it or not. So we called Brent Timmy, the inspector. He came out and looked at it before we did everything. And he inspected through the whole thing. So, you know, we weren't trying to hide anything with a 30 by 40 garage on Highway 57, you know? So, but we would just like to make it right, you know, the variance. But even the way we're zoned, we're supposed to be 40 feet, so we would just like to make it 40 feet. So that then it's all cleared up and done. So.
And after all this is taken care of, all the lots will be
Yeah, because the
acceptable.
Gerhardt property will be rezoned so that they can make the lot smaller, so they'll move the line to wherever they agree upon that puts the buildings in compliance, and then the Fronda property, will be getting larger, which is allowed under a grandfathered,
Okay.
lot, so that's fine.
Any questions? No? Okay.
Thank you.
Anybody else wishing to speak in favor of the proposal? Anybody else wishing to speak in favor of the proposal? No. Are there any new letters?
No.
there are not.
Okay. Anybody wishing to speak against the proposal? Anybody wishing to speak against the proposal? Are there any letters, new letters?
No letters.
No, okay. All right, there's no need for rebuttal, and we'll close that one, and we'll move on to the zoning text amendment for Marty Bryce on behalf of the Pines at Idlewild LLC. Petitions to amend section 4.08 sub 8 sub F 2.B sub 2 of the Door County zoning ordinance to reduce the side and rear yard setbacks for smaller open-sided structures in some multiple occupancy developments.
Okay, very good. The applicant here is on behalf of the Pines at Idlewild LLC. You may recall back in 2011 and 2012, they were in front of you for a multiple occupancy development. Basically, it ended up being 3 fourplexes. It's still a multiple occupancy development, however, the owner uses it as more of a private compound with multiple.
Is that the old
units.
moorings?
Yes, the
That's
old
what I thought.
moorings,
Yeah,
yes.
okay.
In any case, the reason we're here today is when they were doing some landscaping around the buildings, they constructed a pergola with a swing underneath, too close to the lot line without permits. So their options being pursuing a variance or proposing a text amendment to allow a lesser setback in their situation for such smaller open-sided structures, maybe 150 square feet in area, so that's about a 12 by 12 and a half size, just to give you some idea, which would cover things such as pergolas, gazebos, decks, or patios. In their situation,
I didn't see it in here. Was there an explanation of what a pergola is?
if you imagine a covered area or poles supporting a roof type structure, but a pergola has slanted wood.
Open beam.
It's usually open
Beams.
roof, it's no real roof.
Right.
It's decorative
Leash.
structure.
Oh, okay.
Marty can explain that better
Okay.
if you want.
And I believe,
pictures.
Wait.
yes, I believe he has some pictures to pass around as well.
All right.
In that this is a text amendment, I didn't include the structure that caused or created the text amendment. In any case, the lot is very large and there's no way that a variance should be able to be granted because the criteria could not be met. So they moved forward proposing a text amendment for these open-sided structures within non-core mods. And again, it's for mods that are adjacent to single-family residence in the HD, RC, MC, CC, VC, GC, and NR zoning districts. So this text amendment would affect other multiple occupancy developments throughout the county. And that's all I have for you for the zoning. Turn it over to Mariah.
The analysis as far as the proposed text amendment was in the staff report on page 38 in your packets. And the general questions that you look at with a proposed text amendment are whether it's correcting an inconsistency or a loophole, whether it's more consistent with the goals of the comprehensive plan than the existing text, whether it's contrary to the stated goals of the ordinance, and whether there's anything else in the plan that's relevant. In this case, there's not really anything in the plan that directly discusses this matter. So there's not really any analysis to provide as far as the comprehensive plan. As Sue pointed out already, this would be a text amendment that would go into effect countywide. So it's not just specific to the situation at hand here.
All right, any questions? No? Okay, would the applicant please come forward?
Okay. My name is Marty Bryce. I live at 1986 Kettle Creek Drive, De Pere, Wisconsin. I am the general contractor for the project, The Pines. And what we got here is a blunder. The fact that it was built without a permit is not why we're here, but in fact, we did make efforts to have it in a permitted form. We have a I just have a site plan to some degree, and I just want to explain how it got there and why it's there. Whoops.
Oh, there's a
I got microphones there.
Yeah, I see. So what we have is we were going ahead, the owner had it, that was building it as condos to sell off individually. He then put up the one building and has gone to the second building where he constructed it and was gonna start to sell off the buildings, each condo. He then changed in mind and decided to keep it for his family. So he has, out of the first condo that was completed, there is 4 units. Gave one to his son, one to his daughter, didn't really give them to him, just initialed them theirs. He still owns it, one for his, and one for each of his sisters. The second building went ahead and constructed it completely. It's not a 4-unit, it is a 1-unit. It is an upstairs, downstairs, it's a single residential home. So when we did that, then he wanted to change the landscape, change the structure of, or not the structure, but the layout of the real estate to make it more attractive. So with that, we went ahead and put a landscape project together on what we were gonna do. At that time, we sent the project to Sue to show that what we were gonna be doing for landscaping. And we had some lines drawn on it showing what we were pulling out of parking lot and what we were doing to work with some of the landscaping. When we did that, we were under the assumption that we were getting all of our landscape permittable, what we had. We sent over this small drawing over by email, and the pergola was on there, but it was missed. It was missed in the application for the permit. So we went ahead and constructed it for the permit, okay? So with that being said, I do have some pictures that I took, if you don't mind passing the phone around, of what it is, and you can roll the screen and see the structure, what the pergola actually is and where it is located.
Where is it?
We can't quite figure it out, its location.
Gotcha. It is right there.
Okay. So it's okay, yeah, you can barely see straight lines in that neighborhood.
Oh,
So what we're
okay.
talking about is right there.
Okay.
Yeah.
Yeah, and you can roll, there's a number of pictures if you wanna see more of the location and get the atmosphere of what it is and where the location of it is. So with it being an open structure and not an eyesore or not intended to pile or stack or store or do anything, it's basically housing a swing set as part of a landscape feature. So therefore, one way to, when Sue came out to the project to look at it, she was wondering what that was doing there. So it was completely missed, understandable, small plans getting emailed over. Then we wanted to make an attempt to keep it. The owners want to keep the swings, they keep the pergola. It's not hurting anyone, but this was an effort of why I'm here today, to try and keep this pergola as a structure on the site. So therefore, adding to the amendment was one way of getting that done.
Yes.
Is the swing set an issue? Or is it just the pergola that's the issue? Or is it both?
Well, the swing is attached to the pergola,
okay.
but yeah, a bench wouldn't require a permit or require to meet any setbacks, but the pergola itself is considered a structure and needs to meet setbacks.
I do have 4 poles that go in the ground, so
So if he would move it, he'd be in compliance.
Definitely.
So, sir, do you think that a structure like this that you're requesting to maintain where it is, do you think that is a legitimate request to affect all of Door County?
well, the fact that it's an open structure and not an eyesore or not encroaching
I'm
on
talking
a,
about the setbacks.
would you ask the question again? Sorry.
The structure that's there, and with the setbacks, okay, that's going to affect all of Door County.
Okay.
Do you think that is a legitimate request?
I do, because of the nature of the products that's there. We're asking for 150 square feet, and we're asking for open structure. So it's not, I don't know what you would build. It doesn't have a roof. I don't know what you would build that would be of an eyesore or hurt the neighboring property. So I don't see where it's just an isolated thing, but it helps structures of this nature to be built, and this is more of a decorative, usable structure.
But you understand, if we would grant this, it would affect all of Door County.
Correct, I do know that.
Yeah.
You just said number of different open sides, doesn't have a roof. In this case, this particular example does not have a roof. However, as it's worded, it says open-sided accessory, which means if this verbiage was approved and recommended to go to the county board,
They all
a roof
say-
structure would be permitted.
Mhm.
And your real intent is a relatively benign structure, no real functional enclosure for hiding, for storing stuff underneath. It's a decorative, basically, a decorative
Correct.
fixture.
Correct. And it's not going against, like this type of structure is not going against what you see around Door County. It's part of Door County, so.
Any other questions? Okay, thank you.
All right, thank you.
Do you need this back?
Yeah.
Wishing to speak in favor of the application, or the request. Anybody else wishing to speak in favor of the proposal? Anybody else wishing to speak in favor? Any letters?
No new
Other than what we
letters.
got?
Nope.
I keep asking that, but for all three, there are
We
no new
have
letters?
Absolutely no letters
Okay.
for any of the
All
three
right.
uses.
No new letters.
New letters.
No new letters?
Right.
Okay. Is there anybody wishing to speak against the proposal? Anybody else, or anybody wishing to speak against the proposal?
Bud Collins, Administrator for the Town of Liberty Grove, 11161 Old Stage Road. The Plan Commission met on this back in November and discussed it, not at great length, but the concern was that even though this might be an attractive structure here, this opens up the, amendment like this would open up the possibility of countywide, as Don mentioned. So while this might be an attractive and non-intrusive structure, other ones that go up could maybe not be and might be objectionable to neighbors. While a fence is permitted, the commission and the town board felt that this amendment and the setback, or the zoning and the setback is designed the way it seems to keep structures that might be objectionable and not exactly eye-friendly back from the lot line and away from a neighboring house. So they felt this existing setback rule was adequate and should not be amended. The Plan Commission voted unanimously, and the town board at a later date voted unanimously to send a letter of opposition to the request.
Any questions for Mr. Collins? I have one, well, maybe two, we'll see. I read it, and all the towns that responded were against it. What did you envision being built that would be objectionable, since it doesn't have sides to it? What was your thought on it?
That wasn't really discussed. I guess you'd almost have to, if you were gonna do something like this, you almost have to have a review process of each individual project as to what's going up. Because like I say, this one might be nice and attractive, but the next one might be something that looks terrible to some people, and I know a lot of it is subject to people's desires and observations, but that would be wide open in my mind.
Okay, thank you. Okay, all right.
You're saying that something might be built that be aesthetically unpleasing.
Sure.
Okay, thank you.
Okay.
Anybody else wishing to speak against the proposal? Anybody else wishing to speak against the proposal? No letters, other than what's in the packet. Okay,
Can we, just a point of clarification, how far within the setback is it currently?
I didn't bring the file with me, but it doesn't meet the 40-foot setback. If I had to guess off of my memory, I would say it's about 15 to 20.
I thought it said 10 feet.
I know they're requesting 10. I just don't have the number in front of me. I know with other setbacks for different zoning districts, 10 foot is one of those setbacks, and we have within that section the other setbacks for those districts. And I just, because it's not about this particular case, I didn't bring that data with me, to be honest.
Thank you.
Okay. Anybody wishing to speak in rebuttal to Mr. Khan's comments?
I'm not in rebuttal. I just want to point out a fact. I think it's around 25 feet from the lot line is what it is right now, that what is up. But also I just wanted to put out there that we do have the ability to build a fence on the lot line up to 35 feet tall with no permit at all. So I just wanted to, I'm sure you guys know all those things, but just wanted to point that out as well. So, okay.
But as long as you're up there.
Yeah.
Yeah, it says setback of 10 feet on it in red. The change would read, except that open-sided accessory structures with a footprint of 150 square feet or less shall have a minimum side and rear setback of 10 feet. Okay, so it's closer than the 40, he's at 25, he's saying change it to as close as 10 feet. So, yeah, because from that picture, I couldn't tell either. It
That's
looked
what
like
I'm
there
trying
was,
to understand.
it looked like there was a lot more room than the 10 feet.
Yeah. And there it
Okay.
is.
All right, thank you.
Okay, thanks.
Mr. Combs? No, okay. All right, then moving on. We'll go to the Town of Washington for a conditional use permit. Arthur H. and Amanda K. Gibson request a conditional use permit as required by sections 2.05 sub 3 sub B, 4.04 sub 3, and 11.04. The applicants propose to establish a 34-seat restaurant in the first floor of an existing two-story building. The property is located at 1904 Indian Point Road in Section 28, Town 34 North, Range 30 East, and in a recreational, commercial, or RC zoning district.
Okay, and I know that we have Sarah Gibson here to speak on behalf of Arthur. He is out of the country, but I'm gonna start with an introduction, and we're gonna start on page 79. Oh, Mariah already has it up. So, on the island, this is located in the northeast portion of the island, and Jackson Harbor being here. The parcel highlighted in yellow, so it's within a larger area of recreational commercial. And then down here, it's natural area and wetland, which is mostly town property. And now I'm gonna go to page 70, which is oh, I'm sorry. That's which is the site plan for the property. Back in 2011, the home was authorized a single-family residence. At that time, it was the owner's future hopes to establish a bakery or restaurant in the first floor of that structure. But all permits were obtained at that time and put in place so that in the future they could then come in front of the Resource Planning Committee for a conditional use. So fast forward to today, here we are. There is an established single-family residence up on the second floor of the structure. They are proposing 34 seats, which is allowed by the sanitary that's on site, with some seating on the deck as well. Proposed parking in this location. The lot is just under 3 acres in size. Obviously, during the summer months, the traffic on the road is fairly busy with tourism. And now going to the picture that you had previously, Mariah. Rock Island State Park dock here. Rock Island is just off to the northeast. And then we also have, to the south, we have the Elson Dock property. There's also the Maritime Museum owned by the town of Washington. And then further south yet, there is a multiple occupancy development in this area. It's pretty straightforward. I don't really have anything else to add from zoning perspective. They meet all the requirements of the ordinance. So I'm going to turn it over to Mariah at this time.
Can I ask you a question?
Sure.
You said that when the permits were issued for the building and the zoning for that, was what you're referring to is the building was conceptually put together for restaurant use or built that way? And that's what was approved?
They made it 2-story on purpose with the residential quarters up top and planned in the future to do exactly what they're doing today. So they wanted to make sure they had things set up on the lot so that they could move forward in the future, but knowing they needed a conditional use.
And that's what was explained in 2007 or whatever it was?
11, yes.
Okay.
Yep. Mm-hmm.
Okay.
And that's, I just mentioned that because within your packet, you would have noticed the regular zoning permit and the floodplain permit, and that's the reasoning that was included because they were already thinking of this back then.
Thank you.
As far as the comprehensive plan, the property is in an area that's designated as commercial on the future land use map. Obviously, a restaurant is perfectly in keeping with that, so there aren't any planning related concerns at all with regard to the proposal.
Okay. Any other questions? No? Would the applicant please come forward?
Hello, I'm Sarah Gibson. I live at 2206 West Harbor Road on Washington Island. Just give you guys a little history on that piece of property that we're talking about. It's been in my family's name for about over 100 years. It stems back to my mom's grandfather. And with like big in the fishing industry, if you've heard from up on the island, there's a lot of commercial fishing. And with my grandfather and my great-grandfather, they did a lot with building boats. It was actually my grandfather Arthur and his brother that built the boats like the Welcome that carried the mail across, which is now at the Maritime Museum in Jackson Harbor. And the building in question, we actually moved that back in 2011, and it was his net shed where he strung nets in, and that's why we get the 2 stories. The top one then they made into their apartment or single family residence, and now the downstairs is what we're looking to turn into our little restaurant, do a little soup sandwich shop. Being in that location right next to the Rock Island State Park and the Maritime Museum, there's a lot of traffic, tourism traffic in the summer, and just kind of be a little convenience there for the different visitors campers going to Rock Island or just going to visit there. And just a lot of people just go out to the Jackson Harbor area itself. Just it is a beautiful area. You can overlook Rock Island. You have the different museums out there, and just have a little stop off. They can sit on the deck, have a good cup of soup or a sandwich, and just watch boats come in and out, and kind of take in that whole Jackson Harbor experience. That's what we're going for out there.
Any questions, Don?
Just a comment, your brother is in Saudi Arabia?
Yes, he is. He works for an oil company, Schlumberger, and he's over there been there for about 5 years now.
And then he's going to be your partner, it says?
Yes, they come up because he owns the property and the building. So they come up for about 3 weeks in the summer, unless he can sneak away for a little bit more to come up and see us and that.
Thank you.
You're welcome.
Okay, any other questions? No? Okay, thank you.
Thank you.
Anybody else wishing to speak in favor of the proposal? Anybody else wishing to speak in favor of the proposal? No new letters. All right, is there anybody wishing to speak against the proposal? Anybody wishing to speak against the proposal? No? Okay, then we have no need for rebuttal, and we will close the hearing and go into our regularly scheduled meeting. I have to make a comment first. Did anybody else notice the inflection in Sue's voice when she said on the island? Like when the football players announce themselves, they say, the Ohio State.
Yeah.
So we have many islands around here, but Washington Island is the island.
That's how I see it.
I didn't even know I did that.
I got a kick out of that. All right, that being said, we'll open the meeting and verification of proper notice and posting procedures. Everything is up to snuff.
Everything's good.
Quorum present, it should be noted that all 5 members are here. I need a motion to adopt the agenda as presented.
So moved.
Second.
Motion made and seconded. All in favor signify by saying aye.
Aye.
Opposed? We'll forego public comment. Go to correspondence.
None besides the hearings.
Okay. Read and act on minutes of December 3rd, 2015.
I have a question on the minutes, but I'll make a motion to approve them.
There's
Second.
one typo I noticed in the discussion of future meetings, I wrote January 17th instead of January 7th. I don't know if that's what your question
Oh.
was.
That's the one I was gonna bring up.
What was yours?
On the conditions for the Door County Brewery, on item 8, it said delivery truck traffic shall be limited to between 6 and 10 p.m. Would you construe that it means only delivery? So trucks can leave there with material? So yeah, they can pick stuff up at 2 o'clock in the morning?
No, we would interpret that to mean to and from.
I was just curious, okay? Because it says just delivery, so,
I think that's how it's worded for the other one, for the
Okay.
one in town.
okay.
Okay, any other questions on the minutes?
The comment I have is it says 2 vacant lots. And would not have been in favor had those lots not been joined. So when they came here and presented, they presented that paperwork that says it was going to be joined. I'm just concerned that our minutes actually still says 2 vacant
Where
lots.
are you
'Cause
seeing it?
it's at the same motion page, 4 right on top.
Page 4.
It has-
3rd line down. And I know that's how they came initially.
They have recorded it, so it is now 1 lot, but we did not know that. I mean, they showed us
Yeah, well,
paperwork,
officially it
but-
hadn't been done yet
Right.
by the time our meeting came.
Right.
I guess, and as long as we know that it's already been combined, then my concern would be that the minutes imply that a project was approved in a 2-lot pattern, and someday somebody could come back and say that it was approved on top of 2 lots.
I think doesn't the project straddle the lot line? So it's not like they'd probably be able to split it.
No.
back,
I'm more looking for somebody that might have another project someday
Oh,
and say, well, you let them do this on a 2-lot layout, which we really didn't. We knew it was going to be combined.
right.
So personally, is there any way that we could change that?
We already issued the permit.
Yeah,
I mean,
well, in the paragraph, it could just say be located on 2 joined vacant lots, or something like that.
That's, I
Which
guess,
have been joined or something.
So when we issue the permit, we basically copy the minutes and put that into a letter.
and since
that
you've already
forwards
issued the
that-
permit, you.
So I mean,
Oh,
it's
okay.
up to you. I just wanted to let you know how we take
Right.
care of it on our end.
I guess probably what we should do with things like that in the future is the condition there should have been a condition saying that the lots need to be joined and then remain as one.
I was going to
Something like
make
which
that a
at this
condition
point, I don't
until they
think you-
presented documents implying that it had been
Right.
done.
Don?
But technically though, you really can not send the minutes out until they're approved at the next meeting, correct?
We can't distribute the minutes, but we don't do what the Board of Adjustment does. We don't wait until the next meeting before we send out permits.
Okay. That's my Board of Adjustment thinking.
Okay, in the future, I will either make sure it's a line item,
To have it be.
because I don't like seeing a project over top of a property line.
Right.
Yeah.
Shouldn't be done that way. Setbacks can't
I'm
be
sure
adhered to
assessors
and
don't
so
like it
forth.
either, yeah.
But other than that, I didn't see anything
Yeah, same here.
different with the minutes.
If there's no other questions on the minutes, all those in favor of the motion on the floor signify by saying aye.
Aye.
Opposed? Okay, zoning matters. Zoning amendment petition, Rick Gerhardt.
I'll make a motion that we grant, is that how you word it? Grant the zoning map amendment?
Recommend approval.
Recommend approval.
Recommend approval of the zoning map amendment for the Gerhardt property.
Is there a second to that?
I'll second it.
Any discussion?
The lots to the north of the SF20, how long have they been SF20?
Oh, you mean the one that they abut?
Yeah, the 3 or 4 lots to the north.
At least since 95, I would think.
I'm just trying to understand why this one wasn't zoned to SF20 to start with.
I don't know, and because when I looked at the plan, I was assuming that both lots were gonna be deemed like agricultural for that exact reason, and it wasn't, it's shown as residential, so I don't know if that was a mapping error, such as some of the things that Audrey's been dealing with and showing you, but which, like, this one wouldn't have come to you because there's no wetland involved, so we wouldn't have been doing the same kind of analysis, but, yeah, I mean, it's possible that it probably should have been included 20 years ago.
Because my memory is those lots are just as old as this house is, and not seeing why it wasn't done at the time. That's all.
Anything else on that? All those in favor of the motion on the floor to approve it, signify by saying aye.
Aye.
Opposed? Okay, that passes. Zoning text amendment for Marty Bryce. Is there a motion on that?
I'll make a motion, we deny the request for the text amendment.
I'll second it.
Any discussion on that?
Base my,
I'm smiling because Sue was like this, I want to deny it. Anyway, I think that's what
I
the smile
do wanna
was.
deny it. I
It
do.
just didn't want to. Go
I
ahead.
want to make all the motions.
right, I just, we're asking to make a change, text amendment that's gonna affect all of Door County to facilitate one individual and one individual property. We have letters from numerous towns opposing it, both plan commissions and town boards. So it doesn't make any sense to me to make the text amendment in this case for that one particular issue.
Same feelings.
Me too.
Ditto.
Now, you do know we've done it before though.
Not for this
But-
particular type of thing.
But I agree with you. We've done it before, so it's not a fair argument, but we've never done it before when we've had, that I remember, when we've had so many towns
In opposition.
come forward in opposition to it.
Yeah, I think you only had one that wrote in favor, I think Jacksonport
Yeah.
wrote in favor.
So I would rather, I agree with you, I'd rather err on the side of caution on this one. Yeah. Can the structure would have to be moved then, correct?
Correct.
Okay.
Yeah, I mean, you can either apply for variance, but like we said, the chances of him getting it are relatively unlikely. He can move it, and again, to raise the shoreline zoning topic, the rules may change for the unzoned towns,
All right.
so.
All those in favor of the motion on the floor signify by saying, no other comments on this, right?
Well, if he has to move it, is there a time frame?
We can talk with him about what's gonna be happening as far as the ordinance revisions.
I mean, is there a standard time frame for something like this?
Standard, no. I mean, it
Okay.
usually depends on the applicant's situation, it depends on the weather, like in this case, I mean,
Okay,
so,
just so we're clear on it.
yeah.
All right. Everybody okay with that? All those in favor of the motion on the floor signify by saying aye.
Aye.
Opposed? Okay, that is denied. Okay, conditional use permit application for Arthur H. and Amanda K. Gibson.
I'll make a motion that we approve the conditional use permit for Amanda and Arthur K. Gibson.
Is there a
I'll
second to
second
that? Seconded by Sue. Any questions on that, comments?
I'm trying to find the
Do
staff.
Do we want
version.
some,
Page 76.
I was gonna say, do we want
We
some
gotta- we gotta
conditions?
write those down.
Just trying to think where the conditions, where are the conditions, what page?
Page 76.
76. I was one page off, 177. Went forward from there. Quite often we do sign references.
Lighting.
Sign,
The
lighting.
lighting is there.
Right, that lighting's in
Yeah.
there.
We can
Federal
add a
codes.
sign condition.
Typically, we do signs
Just to
also,
reiterate
right?
that they need a
Yeah.
permit.
Right. Other than that, I think they're all within line.
Mhm.
So it'd be the standard conditions included with the, along with the sign.
We don't set, or is it, mine still isn't showing it up, but we don't have hours of operation or anything on there, huh?
No, we didn't. We talked about it at the staff level as far as whether or not that should be something that we talked about, but, or I mean, that we recommended to you, but given that there wasn't any level of concern from any neighbors or the town, and given the activity and the commercial nature of some of the things around it, we just thought that it probably just doesn't really make sense to set hours.
And the only residences on that property, right, the next two properties are commercial
Right,
both
there's multiple
directions,
occupancy
right?
development, and then you've got the ferry and the museums, and, I mean, those things are closed at night anyway,
Mhm.
so.
And you're likely to test,
I can't see them having a big wild party out there unless there's a wedding or something like that, but, I don't think we have to worry about that.
Well, by the time that Sue gets up there, it'll be gone.
All right, if there's nothing else pertinent to it, all those in favor of the motion on the floor signify by saying aye.
Aye.
Opposed? Okay, we have it. Let's go to 6.3, discussion regarding definition of tree plantation.
Okay, so you asked after the last meeting that we bring this back just to take a look at it, to see if anything needed to be done to further clarify the text amendments that are going to county board with regard to the woodland clearing regulations, which basically say, I included them, I think it's the last page in your packet, the amendments that are going to county board. That you can clear
Thank you all.
a tree. Thank you. Clear a tree plantation if the purpose is to be converting that property to another agricultural use. And our ordinance says in chapter 13 that if our ordinance does not specifically define a word, that we're supposed to go to Webster's
Mhm.
Third International Edition unabridged, or a dictionary based on it. So I provided in your packet the online dictionary version from December 6th from Merriam-Webster's online dictionary. That's redundant, anyway, from December 6th. And then just out of curiosity, I looked back, I have Robert's old 1967 and 1971 Webster's versions just to see what those looked like. So I provided the 1971 version, which is very similar to the 2015 online version. In fact, I think it was almost identical, and I checked the 1967 one, and that matches as well. So as far as, that's what, we would use that definition to interpret whether or not somebody had a plantation. We would also take a look at current land use maps to see whether those were categorized as planted forest. We do have a subcategory on our current land use maps. We could look at state managed forest law records to see if somebody had ever enrolled the property in such a program, and that would be how we would make the determination as to whether or not something was a plantation that qualified for that clear cutting exemption. I'll go back to the other one because this one's hard to read.
Okay,
It's tiny.
I get all that. I guess my question still is, I buy 40 acres and it's all wooded. I want to cut it down for pulp. I can't do that? I can't clear cut that because my intent is just to take the pulp off and,
It's gonna depend where you are,
You know.
what town you're in, whether that's designated as one of the woodlands that's protected in the county, what you're gonna do with it afterward, so. I mean, those regulations are separate from the definition discussion.
but are we still addressing that situation? Because I thought that was the real crux of it.
Wasn't the crux, isn't the word cultivation the crux of it?
Right, yeah, what you're talking about, unless I misunderstood you, was, that you just bought something that was wooded but not planted by humans
Yeah.
originally.
There are certain allowances for cutting woods, and let me find that section of the ordinance, because
That,
You may have, the definitions here
yeah,
always end with under cultivation or in cultivation.
yeah,
So if it was a farm that used to be agriculture, now they planted trees under cultivation with the intention of doing something with them in the future, and then potentially turn around and turn it back to a different crop at some other time, that's all under cultivation.
yeah. So that would allow what was Sitte Farms presented to us.
Correct.
We wouldn't have had the
Right.
we wouldn't have been in the quandary we were in.
Right. But to answer your question, you couldn't. There would be limits on what you could cut. If that was first growth, or even if it was, you didn't know what generation of trees it was,
Yeah.
you would be limited. I think that was the philosophy of the ordinance, was to protect some woodlands,
Right,
so.
and again, it's gonna depend what town you're in, because obviously the unzoned towns outside of the shoreline areas, we don't have any jurisdiction there, and then depending what zoning district you're in, there are different allowances, and depending on what you're gonna do with the property afterward, so it really all depends on the specific
Okay,
landowner.
so we're not gonna
situation.
deal with that.
So if you bought 40 acres and it's general ag and it was forested, could you turn around and clear cut it because you want to plant wheat?
Well, if it was a tree plantation, then yes, if this amendment that you guys are recommending
So
county
if it
board
was just a
goes through.
forest that was prior
just-
existing, not cultivated one, and Ken bought that property and wanted to become a farmer,
Then I'm guessing part
then
of it could come
probably
down, but not all of it.
Yeah, you'd be able to cut down probably
That's
some
my
of it.
memory of how those were written.
But
I think it depends how technical you wanna get here. I mean, how technical should you get? If you talk about, under the umbrella of cultivation, I mean, that allows you quite a bit.
oh yeah, but, right.
But he means it-
I'm talking about, I'm not talking about what was previously decided, I'm talking about Ken's particular,
Oh, his technical,
his technical question.
okay.
so I think if we read through
This
the
time I'm coming
whole,
up with a hypothetical.
That you got mad at me for last month.
I think
if you read through the whole section, there are different steps to figuring out your question, and I think if we took time to read through all of that, I think some of our questions would be cleared up. Because it talks about woodlands areas possessing both of the following characteristics on the effective date of the ordinance shall be subject to the requirements below. So there's some criteria right there. There is allowances for clear cuts of certain areas. There's exemptions if it's certain types of trees. We don't even count those as part of the clear cutting. So I really think to be able to answer a specific question like that, we need to read through the entire section to be able to answer
So
that
you'd
question.
want to create a hypothetical and then apply the code to it.
Right.
So after you
Which is
buy the
what I was
40
trying to do
acres.
Yeah.
2 weeks ago.
so. Call us before you buy the 40.
Yeah, and you know,
Keep in mind, if you start blasting ahead of time, the trees die.
Yeah.
yeah, I'm not saying I would look to do that, and I can't imagine anybody wanting to do, why would you want to cut down all your trees? But I thought we wanted to address that if it ever did come up, say somebody bought 40 and they wanted to build a house on that 40
can.
right in the middle, but they wanted to, for some reason, they
Live in a
wanted a
field.
great big yard, so they wanted a 20-acre meadow
Well-
and just a perimeter of trees around that, you know, so nobody can see in. Would they be able to do that?
Probably not, but again, it's gonna depend on, you can clear enough area for driveway and trees and yards, and I forget what the allowance is for, but again, it also depends on what zoning district you're in, so depending on the district you're in, you can clear higher percentages in some districts than others.
Okay.
And then after, so let's say your 40 is one that's gonna be subject to those regulations. We would look at what district you're in and we could say, okay, Ken, you're in District X, you get to clear 30% of it without us even blinking an eye or worrying about it. So you can go whack down 30% of it, and then on top of that, you can clear for homes. You can now clear for agriculture.
Okay.
If it's a tree plantation, you can clear for agriculture.
Okay.
You can, so again, yeah, like Sue said, it really kind of depends on what the person is talking about doing.
But that discussion wasn't part of what came out
Right,
of
we
the
were just,
Waseda
I think you
files.
guys wanted to make sure that everybody had a grasp on what a tree plantation was, since we're now gonna presumably have this regulation in the ordinance.
Well, I looked
that-
at this and I thought, well, this words it pretty succinctly. And we wouldn't have had our discussion about Waseda Farms or needed, not that it was a really lengthy conversation, but we wouldn't have needed it in the length it was if this was on the books, because this would have addressed the problem.
Right.
Correct.
He could have gotten his,
Right.
he could
Sure.
have just done
He
it, or
could-
he could have gotten a permit. He wouldn't
could've
have needed a
just-
permit.
He could have
Done
just done it,
Yeah.
yeah, I have to check
So-
this.
Okay,
I mean, and as far as the regulations in chapter 5, we had talked well over a year ago now, maybe more like a year and a half. Sue and I think Becky was here at that meeting about that being a chapter in the ordinance that really needs some attention. That's the natural resource protection chapter. And some of the woodland clearing provisions that we've been talking about conflict with some of the clearing provisions with regard to what you can clear on an escarpment area. Both of those conflict with what foresters consider good practices, and then the maps that go along with that chapter were created 20 years ago by hand, so that's something that we have been kind of attempting to work on, but Becky's really only just gotten started on that probably in the last month as we've wrapped up the hazard mitigation plan development, so you'll be looking at that stuff again at some point, probably in the next 6 months.
okay.
So how old is this section of the code?
95.
I don't think we've amended it in 20 years.
Because the state has been updating what is agricultural definition relative to trees.
That and
That's
we
the
have
concept
updated,
of-
we had to, if you look in chapter 13 of our ordinance.
And the
we-
federal government for that
Yeah,
matter.
we do have a definition of agriculture, which is two-part, and for the exclusive agriculture district in Claybanks, we had to match the state's definitions. We added that in there. We have not looked at changing the other.
There's forestry
I
that's
think it does
inside the ag
include-
world.
I think it does include forestry in the
Well-
first part though, doesn't it?
And I don't mean to cut the conversation off, but are we happy with what they've got written on 88 for under E, the proposed amendment?
Yeah, I thought
Are
I
we
had.
happy with the way that was worded?
See, I thought I thought I'd read in this packet, and I can't find it, that the original example said other permitted agriculture uses, which means in theory somebody couldn't cut all the trees down and replant the trees. But this new one took that system out, so it implied that it could be
Well, no, this
in
is,
ag.
you mean the,
At one point in time, it was worded in a way that if you cut down a tree plantation, because of the way it was worded, you technically couldn't put in another tree plantation. But then when our packet came out, and I was gonna bring that up, when our packet came out, it was written this way, which means ag is ag.
I'm not
Doesn't care what the
recalling
product
that. There already is an allowance in chapter 5 that if you have what we are now calling a tree plantation, that you can completely clear cut if you're gonna replant.
Right, but at the time, the wording was a little differently, and
Okay.
then it came through this time around, then it was fine.
Well, because page 88 is exactly what was in the December 3rd packets that
Correct.
went to hearing.
Correct.
Okay.
It was
So I
before
guess-
that it was not that.
Okay, I'm not recalling that document, but yeah, but so on page 88, that language in red is what you voted 2 weeks ago to forward to county board, which I believe, is that going next week or in January?
Are we happy with how that's
22nd.
worded?
I mean, if you're not, you can
And-
propose a modification on the county board floor.
Well,
I
and my
guess.
question is,
But-
where do we go from here? Because we have just down here, discussion regarding definition of tree plantation. So if we agree that we're happy with the definition we got and this amendment, do
We
we,
feel it's still acceptable to move forward, or it should be.
how do we move forward if we feel that's?
Well, we already passed it.
Right, if
Passed
you.
it at the last meeting.
Right, so what you would do, I guess, if you think that the definition that we showed you from Webster's today, which is what we would use in my explanation of how we would go about.
Oh,
determining-
this is the way
That's what
we
you
passed
forwarded.
it.
We
Right.
passed it, yeah, 2 weeks ago.
Right, but what you guys wanted to do was you didn't wanna hold up Tom Lutzy
Yeah.
by worrying about the definition, at that point you wanted to just forward that to county board and then let them act on it and then look at the definition of tree plantation to see if that was something that needed
Oh,
further
yeah, yeah.
attention.
All right.
So you
I'm
could
sorry.
either, if you're happy with the language that got forwarded or is going to get forwarded to county board and the definition that we would use, then you don't need to do anything. You just go to county board and vote on it as a body. If you're not happy with either the text amendment language in red that you already forwarded or that's already getting forwarded, or if you're happy with that language but you feel like you need to add a definition, you could propose a modification for a modified amendment on the county board.
So at the end of last meeting, we approved this verbiage to go to county board. Our concern was whether or not tree
Tree
plantation
plantation.
needed a definition, or the definition in the book dictionary that we referenced was acceptable to be applied towards the verbiage that we chose.
Exactly.
And as far as I'm concerned, yes, it works together
I
fine.
think we should just move along with this,
Yes.
and if something comes up in the future, which I doubt very much, we can deal with it at that time. I think that we're getting just too technical here.
Well, you know what?
That's
We have
just
to
my
get
opinion.
technical.
No,
We need to make ordinance standards as black and white as
Yeah.
possible, which is a lot harder than you'd think because we have to make very technical decisions. So
And
we
that's
need to
why I
make
did
sure
that
everybody
scenario.
understands like what.
I wasn't
yeah.
at the last meeting,
Yeah.
but I have a comment that if this is what's going to the board, you might want to just change something. Not the red that you've approved, but the background information as it's written here. In the paragraph that talks about the background, in the last paragraph where it says this amendment would allow clear cutting of trees, it says if the purpose of the clear cutting is to establish a different permitted agricultural use on the property.
Oh, that's where I saw it. Okay, I did see it.
But in the red down below, it says if the purpose of the clear cutting is to establish a permitted agricultural use.
Oh,
on the
yeah.
Right,
take out
and
different.
that's how the red was originally, was implying that you could not, it
Right. Go
back
implied
to
a
more
So
purpose.
trees.
if you leave that in the background for
Yeah,
purposes
get rid
of
of
giving
that.
the board, get rid of that.
The different.
The word different.
I'm trying to remember where we were in the process with sending stuff to Carey.
It's already approved and ready to go to county board. Now, whether Lori made copies for packets that you're gonna get December 22nd, I don't know.
No.
I think
Oh,
the
let's get
key
down.
is that it's already allowed if you're, that's why I put the word different in there. So that may very well be of confusion to county board members that
It
don't
will
know
be,
what it is.
and I absolutely,
But-
and I agree. That's the point that I was seeing that I couldn't find just a few
Yeah.
minutes ago.
Cause and I did that purposefully because it already is allowed to clear cut
Yeah.
for the purpose of replanting with trees. This would be clear cutting
For a
So it's-
for a
different
different
purpose.
purpose
Okay,
than tree
I see what you're
plantation.
Right.
So, and I am not gonna be at county board next week, but
I see
Sue's
your
gonna be.
point.
'cause we
Well,
have a
doesn't
couple-
having different or in or out pretty much say the same thing when it says a permitted agricultural use? Because if you clear cut trees,
Okay,
And-
if you're talking about the red text,
Yeah.
the red text is correct. I have no problem with
yeah,
that.
I agree.
What I have is the background
with
explanation
the word different.
says it differently.
And the use of that word different, if they read that first,
Right.
will imply instantly that it cannot be a tree plantation
Sue
if they
will
misinterpret it.
Stand up
Oh,
and explain that
right,
immediately.
it could
when-
say that you can
Yeah.
clear cut
But now you
to
can't
put,
plant
to
trees
plant
again.
oats, but you
But
can't
not
clear,
trees.
clear cut it to
Plant
plant
trees.
trees.
Exactly, even though the ordinance already says you can somewhere
Yeah,
else,
yeah.
just the background information will
Right.
apply
If
something
we
differently.
can, we
only
will
Please do.
get it changed. I am fairly positive that Lori probably has all those packets made and posted, but
Well, the county board that hasn't posted, but that
Yeah.
doesn't mean it's not ready to go.
right.
Cause I checked it a minute ago
Okay,
to
I
see if
wasn't
it
there.
was.
Okay. But at any rate,
Here.
Sue
Well,
will
I
be
fit her
there
at home.
on Tuesday.
I was
So-
gonna say, couldn't
I
we
was gonna
make a
say-
motion to take that word out anyway?
It's
Well,
not,
that's
it's
just-
not, it's not part of, the
that's
red
not
is the
amendment.
text
It's not part of
amendment.
the resolution.
Change, that's right, that's
Yeah.
right.
The ordinance will only be the red.
Right.
That's
Yeah.
just background information.
So you'll just clarify.
Why couldn't you just make a hard copy and present it at the Door County Board meeting and on this particular page and explain
I
why
think-
there's this.
I think she
No.
can just
The
explain.
easiest
I
thing
doubt
is
that
going to
there's
be
even
that
gonna
if it's
be-
already been through the process, all of us will just have to acknowledge that the intent was that now this is allowing somebody to clear cut trees for another agricultural use. They already can clear cut trees now and plant trees on top of that spot.
We can simply say that the word
If someone even picks up.
If somebody picks up on it.
Yeah.
different
Yes.
was intended to be removed in the background
What
explanation.
word are you speaking of?
The
They're
word
not talking
different.
about the
Different.
text amendment.
I know
Talking
that.
about the
You're talking about
paragraph
the
above it.
Paragraph
Look
above
at
it.
it.
The sentence
Two paragraphs.
above it.
If you read that first, Don,
Where
it
is it?
implies that the intent is
Down,
to
right
allow
there.
them
Right
to
there.
plant something other than trees, but not
That
trees.
This word right here.
Yes.
So it's in the background information.
I
I will
see.
check with Lori if packets haven't been printed, and I don't know if you get physical or just on
No,
your
just
Zoom.
on
No, we just get
I'll
it.
see if we
It hasn't
can
been posted
switch
yet.
out and
Yeah.
And
take
if
that
not,
word out.
then you simply
If
say it
not,
was
I'll-
inadvertently left in. But
If
the
there's a
red text is
concern-
correct, right.
Yeah.
I understand.
Idlewild Golf Course
You can-
is in
I can
that
think three
swampy,
people.
correct?
Shoreline zoning only.
Shorelands, okay. But that's within 1,000 feet
300 feet of a navigable stream in that area
and 1,000 feet of a,
from the bay.
From the
oh,
lake.
from the bay.
From the
Yeah.
lake, yeah.
Or the
So a
lake.
man-made pond or lake wouldn't matter.
Most of that golf course is not in county zoning.
I know.
There's just a little strip near County M, north of, is it Haynes Road? That's in, but I know they have done some work, but it was shrubs and I don't even know that they got close enough to affect shoreland regulations.
Okay.
But I can look into
Well,
that
yeah, and I
closer.
asked if it was within zoning and it's not, so they can clear cut
Shoreline
that.
zoning is
But
not
even if
tied to
it's
that.
shrubs, it could be
I'll have to look into that closer.
construed as,
And it's a strange
Trees.
navigability determination
I
there.
know,
So,
and they clear cut that,
But that's separate from this.
I know.
right.
She's talking state zoning there.
And,
mandated
and
zoning.
what they cleared wasn't a woodland. Didn't,
Yeah, I
I
don't know
mean,
that
even if
shrubs
it
would
were in
qualify.
zoning, it wasn't a woodland. Per the woodland definitions, you have to have trees of certain height that
Okay,
have
okay,
15 feet in height and cover at least 70% of the land surface
Okay.
with shade. So that area wouldn't have qualified under these regulations.
right.
Always worried
But
about
I-
your golfing.
I know exactly where you're talking.
Yeah, yeah, that was,
Front nine or back?
cause I was gonna, actually, back. Yeah. Go ahead.
I just wanna, say something, Mariah, in that you are absolutely right. We should be as technical as possible. It's true.
Yeah, because
It's
otherwise,
very, yeah, and, you know.
nobody wants us to have the latitude to have gray area, including us, because
Yeah.
it's.
Too
I mean,
problematic.
We want it,
Yeah.
that's. yeah.
But at all times, can you be as technical, you know, as possible?
Do your best you can, you assemble
Right.
the variations that happen
Yeah.
all the time and work on coded,
Yeah.
coding to
Okay.
work that way.
Yeah.
Things come up
Okay,
and
so we'll
correct
check
it.
with Lori.
Okay,
But
so we're
everybody's
okay with
good
that, we're
with
okay with the
the-
definition of tree plantation.
Okay, so then we don't need
Is
to do
that what
another
we want
text.
to
I'm
cover?
fine with everything.
Okay.
Next meeting.
All right. All set with everything? Any questions by anybody on any of the prior matters?
No, I don't see an item on here about topics, but I do have a question about a possible topic.
Okay,
Can I do that? Don't we have to approve the hazard mitigation plan?
Yes, we are gonna do that at the January 7th meeting.
Okay.
Yeah, the deadline to get it to FEMA, I think, is at the end of January. I think Becky's got it pretty well done, but she took vacation this week. so-
Okay,
Because we talked about it, yeah.
Yeah, yeah, we did intend to do it this week, but then she decided to go on
I
vacation
think
this
I
week.
have that written down. Someone's- Okay, so January 7th is on, okay, yep, I've got that one. No meeting on the 21st,
Correct.
okay, so we would have a meeting on February 4th, and the next meeting after that would be February 18th, possibility.
Which we will likely, we just got 2 new applications yesterday, so they're
So
continuing to.
I will
will
let
not
you
be
know that
here.
I won't be here on the 4th of February.
I will not be here in February.
At all,
At all?
okay.
And I will not be here in the 18th of February.
Okay, wait a minute.
Wait,
Dave and
wait.
Ken are doing everything.
Okay,
so
but you
it's
will be
January,
here-
January
wait.
7th?
Okay,
Wait,
I'll be
let's
gone the
just-
4th, but I'll be here the 18th.
So the 18th will be 1, 2, and 3. And the 4th will be 1, 2, and 3.
Yes.
The part-timers, no, we'll just deal without them. That's all right.
Let's see, it's usually Florida.
However, in saying that, I'm okay then with the rest of February, but March
When you're the part-timer.
March 10th would not be a meeting, would it? Because it would be the first
No, it would be
Thursday.
the 3rd and the 17th.
So that's fine, then I can't
Okay.
be considered
So
part-timer.
let me make sure I've got this correct. So Dave Leinau is a no on February 4th.
Fourth.
Sue is a no on February 18th, and then Don is a no on both February 4th
Right.
and the 18th.
Yeah.
Got it.
And the first week in March.
And March 3rd.
Oh, yeah, I
Yeah.
should
Is
say
that-
1, 2, and 3, and 1, 2, and 3. Okay, yeah.
Okay, so
we got
or
3 here.
3.
Don't anybody miss the February meetings of the 3 of us that are left?
Do we get their compensation?
You and I are the full-timers, I guess.
Well, yeah, really. We get their compensation.
Okay.
Okay.
And we're happy to give it to you.
And the reason I brought that
We'll
up
make
was
it a
because
4-hour meeting.
I will be gone March 9th and 10th, which is
Okay.
Wednesday and Thursday, and I wanted to make sure that we didn't
Nope.
schedule anything for that
Yeah.
Thursday. Okay, are we all set with everything else then? We're all okay? All right, well, that being said, if there's no further business, I would entertain a motion to adjourn.
I'll make a motion to adjourn, Mr. Chairman.
Motion made by Mr. Lino, is there a second to that?
I'll second.
Second by Dave Enigl, all in favor signify by saying aye.
Aye.
We are adjourned.